What's up, everybody? What's up? What's up? What's up, everybody? What's up? What's up? What's up? Let's see here. Share the live stream. Mm, let's do um, share. YouTube. Um, what's up, everybody? What's up? What's up? What's up, everybody? Let me get my stuff set up. Here we go. Gonna keep the Magna Carta. We're gonna keep the Constitution. Then we're gonna get the Bill of Rights. What's up, everybody? What's up? What's up? Mic check. Does it sound good? Does it sound bad? Let me know. Let me know. Should sound pretty decent if I stop moving. Let's see here. Y'all, it's cold outside. What's up, everybody? What's up? What's up? What's up? What's up? It's cold. It's cold. It's cold outside. It's cold outside, y'all. Say it's cold outside. It's cold. What states are y'all from and how cold is it where you're at? Let me get off of this. Mm, let's share. It's not sharing. What's up, everybody? What's up? What's up? What's up? Oh, yeah, that's what I needed. What's up, everybody? What's up? What's up? 34 degrees. Trash. Trash. What states are we from and what's the temperature in your state? Let's see. Let's see. We're going to go to the common law and we're going to go to, let's see. I keep forgetting I got stuff and I don't. Let's see. I always like talking about that case. Let's talk about that. Let's see if some more people come on. What's up, everybody? What's up? Let's see. Let's see. We're gonna read that. We're gonna read. Oh yeah, we're gonna go to New Jersey. New Jersey. I wonder how cold it is in New Jersey right now. What's up, everybody? What states are we from? What state are we from? What states are you from, and how cold is it in your state? What's up, everybody? What states are we from, and how cold is it in your state? Let's see. We got New Jersey. We got Massachusetts. Let's see here. Let's see here. I think Oklahoma said it. Oklahoma. Okay. They said, we're not telling you, bro. We're not answering the question. All right, let's talk about some common law. I watched a live stream today. Uh, I don't watch it like I'm actually interested, but I like hearing what people, I don't like it, but I listen to what people are saying and trying to communicate. And the number one conclusion that I found is that people are going to have to learn how to build community. And I don't think people realize the power in community. People, this lady, I saw this lady's live stream today. She complained about how, she had a child support issue, and the government and the courts just did her so wrong. And I'm not here to judge or shame nobody, but we don't know. This is what happens when we don't know our history. During the time of the Revolutionary War, these people would pass out pamphlets. These people would prove everything that they were saying. They stood in whatever type of towns and settlements that they had, and they made noise how government corruption is happening in their colonies at the time. And I don't think we understand the significance of that. Look up. Um, because we live in an age where everyone thinks, and by everybody thinking they're an individual, they think they don't need the community. That's how people live. People live their life. When you get on the interstate and people are driving, people drive like they're the only ones on the road, and they're the only one that has somewhere to be, right? So we've breeded so much selfishness that we don't know how to build community anymore. When I was a kid, everybody knew who everybody was. You didn't have to be best friends with them, but the family down the street knew who you were. The We would ride bikes and get in trouble, okay, they knew where to go get us from if we got in trouble, but there was community, and we don't have and we get on the other side of not having community, and when the government's corrupt, we don't know who to go to solve these problems, and the answer is the community, right? We think, and these scammers on the internet keep telling you this magical paperwork is how things get fixed, and it's not. The paperwork goes to the people you complain about. There's no way that works. Right? We're supposed to have a community to the point where, well, it doesn't matter who's on the jury because we all are on the same wavelength on what it means to be right or wrong or have justice. And we're supposed to be debating or arguing or commending in actual conversations throughout society and our interactions. But we don't have those things anymore because we're so glued to our phones, we're so glued to social media and Netflix and all of these different things that when it comes time that we're facing opposition, well, we have nobody to go because we let Facebook tell us what's right and wrong. But that's another day. But I want to read this before I get started. Here we go. Let's see. Let's see. They said as the year 1750, people, the average colonist, would have worked about 21 hours a week, and they worked for themselves. They said they read at the equivalent of be considered a seventh grade level of comprehension. That means a college graduate. Because college graduate then didn't mean you knew a lot of big words. It meant you could comprehend the depth of a situation or a circumstance or a subject matter, right? They said that the colonists of the 1750s, they competed in shooting events weekly. They said they kept that thing on them. They knew how to use it at all times. These are the colonists. They were universally trained in law, not fake patriot law, the law. They knew the law. I heard a dude say one time, if you I forgot who it was. Some dude came from France and visited Kentucky or something like that, and he surveyed during the time of the country starting that if he could go into anybody's home and find a King James Bible on anybody, and it's not we're not talking about King James Bible, that's not the point. He said you could go into any, American's home, and the average American would be considered a lawyer because they didn't read foolishness. They said they read the almanac, they read the Bible, and if you were reading the Bible, then you would have been considered a lawyer because that's where you'll find the real law. And they said if they got on the jury, well, then they were well versed in what was right and what was wrong. They said all they needed was the 10 commandments and they could handle a jury. They said they were universally trained in law, not patriot law, real law. They were universally trained in religion. They knew about all the major religions. They had illiteracy rate of less than 0.4%. That means not a percent, point 0.4 of a percent. Only 1 in less than 1 in 200 could read. They said they were litigious, which means they sued people often, and they knew how to do it without an attorney. We don't know how to do that. They said they were animated by the love of freedom. They didn't sit in meetings, but they were actually on their feet passing out flyers, filing lawsuits, etc. They said they didn't complain. They got to it. This dude named Edmund Burke, a British statesman and political thinker at the time of the American Revolution, made a widespread historical survey of the colonies. He said in 1765, he described them as follows. He said they could smell the approach of tyranny. He said, "Permit me, sir, to add another circumstance in our colonies which contributes no mean part towards the growth and effect of this untractable spirit. I mean their education. In no country, perhaps in the world, is the law so general a study." He said, "All who read and most do read endeavor to obtain some smattering of the science. He said, "I have been told by an eminent bookseller that in no branch of his business, after tracts of popular devotion were so many as those on the law." He said they didn't sell no books, but books on the law. They said this was the average colonist at the Revolutionary War. They said, "No." They said they could smell the approach of tyranny when they got the word. They said, "No, it's time to hit the books, boys. We think we on that bull," and they got to it. I tell you this all the time. When the country started, when William Blackstone came out with the commentaries on the laws of England, they said more people bought those books in the American colonies, they would be the states by then, than they ever sold in England. And William Blackstone didn't even like the colonies. He said they weren't entitled to the common law of England. They said, "Right, all right, we'll take 50 copies. Go ahead and send those." And they said after the Revolutionary War, they surveyed that more people bought that dude's book in America than they did in England. Why? Because they knew they couldn't play. They had to know the law. And then when their actions were displayed, they could back up everything they did based on the law. They were not ignorant. See, they want you to think they were just ignorant, racist people with 2 teeth in their mouth. Nope. Them boys got to the books. A farmer got to the books. There was no such thing as ignorance. They said a point 4 out of 1% was illiterate. It means he said less than 1 out of 200. He said if you were to count the colonists, only 1 dude might not have could read. He said, so this bookseller, an eminent bookseller in the colony said, "Well, I don't sell any other books but law books." He said, "The colonies have now fallen into a way of printing them for their own use." He said, "I hear they have sold," and I'm reading before I say it. I say it before I read it. I hear they have sold nearly as many of Blackstone's commentaries in America as England. I got a Supreme Court case that said they sold more in the colonies than they did in England. They said General Gage states that all the people in his government are lawyers, not attorneys, lawyers. What does that mean? That means they know the law. They knew it. They said General Gage states that all the people in his government are lawyers, comma, or smatterers in law. And that in Boston they have enabled by successful, I don't know the word, wholly to evade many parts of your capital penal constitutions. They said the smartness of the debate will say that this knowledge ought to be taught or ought to teach them more clearly the penalties of rebellion. But my honorable and learned friend, the Attorney General, will disdain that ground. There's a lot of ancient English here. I'm trying to, I'm trying not to bore you with. But the whole point of this is that these people were not ignorant. They didn't complain and hope somebody saved them. They hit the books and they got diligent. I mean, they didn't say, "Oh, I'm gonna go get an attorney." No, 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 no. They got to it. Proverbs 28:5 says, "Evil men do not understand justice, but those who seek the Lord understands all." He says, in Apostle Paul says in the book of Ephesians that having their understanding darkened, being alienated from the life of God because of the ignorance that was in them. Thomas Jefferson said in 1823, Laws are made for men of ordinary understanding and should therefore be construed by the ordinary rules of common sense. Proverbs says that evil men do not. Psalms 119 says, the entrance of your words gives light. It gives understanding to the simple. Second Timothy 2:7 says, the Lord will give you understanding in everything. In what? Everything. So they didn't complain. They couldn't understand the law and that they needed an attorney. So they went and got books. They said they figured out how to print their own. They said they started going to the bookstore. They said they figured out how to make their own books on the law. And as a result, they could fight any ignorance or any usurpations of the law when some bar member or some attorney says that he knows the law better than them. They said, no, we got to it. Oh, this is fun. Proverbs 18:2 says, a fool takes no pleasure in understanding, but only in expressing his opinion. That's what you see on TikTok all day. All these people just yapping, no understanding, can't prove nothing, just coming off of ignorance, just spouting ignorance all day. Proverbs 24 says, rescue those who are unjustly sentenced to die. Save them as they stagger unto their death. Don't excuse yourself by saying, look, we didn't know. That's what people do every day in America. All these parents who lost their kids to child support, having their payments garnished and everything, and they cry out for help. And then the people say, oh, look, we did. Oh, I'm sorry. Well, we didn't know. Oh, it's fun. Yeah, so we're supposed to have understanding, and we're supposed to be spreading this understanding. The colonists were not ignorant, racist, uh, nobodies who whine and pouted about how the government was mistreating them. What was I going to talk about? I was going to talk about the common law. So I need to go to the Constitution, and we will talk about the common law. What's up, everybody? What states are we from? What states are we from? I said, I don't want to talk about this. I want to be distracted. I want to be entertained. Do a TikTok dance. Sell me something. Let's see. Let's see. Let's see. Constitutional interpretation. Virginia. Virginia. Let's see. Let's see. Let's see. Constitutional interpretation. All right, let's read some stuff and then we'll see how much we get in. All right. Something. There we go. All right, got a lot of tabs open. Let's see here. Where will we start? We'll start where we always start. All right. This is a circuit court case, excuse me, by a guy named Joseph Story. Joseph Story, you can look him up, was one of the first Supreme Court justices, federal Supreme Court justices of the country. I believe he's from Massachusetts. Um, but one of the first law dictionaries that were uh, claimed to have been able to define the words in the Constitution. That dictionary was submitted to him for review before it went to publication. So this isn't a nobody. This is one of the first Supreme Court justices. Okay, so his name is Joseph Story. So Joseph said, This was before he became a Supreme Court justice, but it says that it can hardly be doubted that the Constitution, talking about the United States Constitution, is predicated upon the existence of the common law. Say common law. It says that it can hardly be doubted. This thing is not up for debate. The United States Constitution is predicated upon the existence of the common law. Say common law. They said this has not been denied by any person who has maturely weighed the subject and will abundantly appear upon the slightest examination. They said the trial of all crimes, how many crimes? All crimes shall be by jury. They said no one can doubt. He said no one can doubt that for the explanation of this term and for the mode of conducting trials by jury, recourse must be had to the common law. Say common law. They said that he said that the Constitution of the United States says that judicial power shall extend to all cases in law. He said this is inexplicable without reference to the common law. He said, what is a writ of habeas corpus? He said the common law and that alone furnishes the true answer. The existence of the common law is not only supposed by the Constitution, but it is appealed to for the construction and interpretation of its powers. Say the common law. He says, what are crimes and offenses against the United States? He said, here I contend that recourse must be laid to the principles of the common law. He said we resort to the rails of the common law to give them an interpretation. He said Congress has provided for the punishment of murder, manslaughter, and perjury, but it has nowhere defined these crimes. He said Congress doesn't have the power to define crimes. So he said, let no doubt ever be entertained with trials. That for the explanation of trials, what does that mean? That means when you get into trial, you can't try to redefine what a crime is. You have to go to the common law to know what a crime is, and you can go nowhere else in this country to define what a crime is. A crime is not what they write on paper. They said Congress can't write what a crime is on paper. It's not possible, according to the law. So they said Congress has provided for the punishment of those things, but it can nowhere define them. If you want to know the definition of crimes, the explanation of them must be sought and exclusively governed by the common law. Say the common law. They said upon any other supposition, judicial power would be to the mere arbitrary pleasure of judges, to an uncontrollable and undefined discretion. That's what people complain about every day. They said, whatever you think, he says, whatever you think, he said, whatever may be the dread of the common law. He said, whatever you think is too old and too difficult and too outdated concerning the common law, leaving everything in the hands of one judge is way worse. He said the despotic power of a judge could hardly be deemed more desirable. He said there are a great variety of cases arising under the laws of the United States, which are judicial power. They said the legislative will cannot be effectuated unless by the adoption of the common law. Say the common law. He said nothing is more clear. He said this stuff is not up for debate. You don't have an opinion to try to add to this. For the interpretation and exercise of a vested jurisdiction of the courts of the United States must be governed exclusively by the common law. Say the common law. A law book on the Constitution says that constitutions must be construed. What do they mean constitutions? Why do they add a S on it? Because every state has a constitution. And when you get into federal things, then there is a federal constitution. They said constitutions must be construed with reference to common law. They said the federal and state constitutions did not repudiate the established common law. Who established the common law in this country? The state and federal constitutions. So if I ask you what the law is in this country, there's but one answer, and that is the established common law. They said this fact has been taken into consideration by the courts in construing clauses in state constitutions. They said in such cases, the courts of the state are always to regard the language of the Constitution in its common law sense. They said there is no common law of the United States. We're talking about the federal government. But they said this is distinguished from the common law of England adopted by the several states. There's a difference between the United States and your state or the several states. They said the common law of England was adopted by the several states. And they said in interpreting the federal constitution, recourse may still be had to the aid of the common law of England. It has been said that without reference to the common law, the language of the federal constitution could not be understood. Say the common law. They said this is due to the fact that this instrument called the Constitution, state or federal, and the plan of government, state or federal, was founded on the common law as established in England at the time of the Revolution, not as established by Great Britain. There's not a place called Great Britain. There's a place called England, and there's a people called English, but there's not a place called Britain. Britain was what they would have called a legal fiction, a fake name. So they said that this is due to the fact that this instrument we call the Constitution, state or federal, and the plan of government, state or federal, were founded on the common law at the time of the Revolution. They said the Bill of Rights are taken exactly from the common law and must be construed with reference to the common law. They said, for example, the United States Supreme Court has taken the common law into consideration in construing the Fourth Amendment. They said it is not only proper but necessary. This is the Supreme Court of Florida. Not only proper but necessary that reference be made to the principles of the common law and ascertaining the meaning of the terms in the Constitution. The Supreme Court of Ohio said it is to the common law that we must look to for the legal definitions. You can't even define the words in the Constitution without going to the common law of England to get the actual meaning of what is being said. They said it is to the common law that we must look for for the legal definitions and judicial ideas in interpreting the federal and state constitution. The Supreme Court of California said the common law formed the basis of almost every right secured and every remedy provided by that instrument. What instrument? The California Constitution. So, do we understand that the common law of England is how you are to see state and federal constitution? The United States Supreme Court said concerning that the 13th century commentators, who were the 13th century commentators, the people from the 1200s who would have construed in that, found that the privilege against self-incrimination found in the Fifth Amendment was grounded in the Bible. They said, where did this privilege against self-incrimination come from? Where did the right to remain silent come from? Where did the right not to be a witness against yourself come from? The Supreme Court of the United States said it came from the Bible. They said the principle that no man is to be declared guilty on his own admission is of divine decree. Any questions? Any questions? What is the common law? The common law is distinguished or the opposite of statutory law created by the enactment of legislation. They said the common law is affirming and enforcing such usages and customs, particularly the ancient unwritten laws of England. See, an attorney will tell you that the common law is judgment law. Magistrates can't make law. It's not possible in this country. And the only lawful judges in the 50 states are the people on the jury. And they're the only ones that have the power to make law outside of the legislator. So if they declare something not to be law, then that would be the law for that particular case. Because you can't make fake laws to cover every circumstance. That's what equity teaches. Equity teaches we will write statutes to try to prevent behavior, and you can't do that because that's how you try to control a group of people who were never designed to be controlled. They said this thing called the common law is applying and enforcing such usages and customs in the sense, particularly the ancient unwritten laws of England. What's the unwritten laws of England? Trial by jury, grand jury, gold and silver is money and nothing else. Sovereign immunity that says that the sovereign or the king cannot be brought into the courts that he created by way of a constitution without his consent. That's what it means to be and using the customs of ancient unwritten laws of England. They said it's not written down. The Supreme Court of California said that the common law of England is the rule of decisions in all courts of this state. So if I was from California and I wanted to know what the law was, okay, that's the law of California. They said the common law is opposed to statutory or equitable law. They said this thing is not friends with statutory or legislative enactment. They said this common law is the real principles that go all the way back to the Bible. They said that this is the Supreme Court of Wisconsin. They said the common law was enforced in the territory of Wisconsin and shall continue to be the law of this state. The Wisconsin Supreme Court said that statutes are not to be changing the common law. A North Carolina court said the Uniform Commercial Code is in conflict with the common law. The United States Supreme Court said the common law of England, our ancestors brought with them its general principles and claimed it as their birthright. They said the common law of England was their birthright. The Supreme Court of California said the common law has not been repealed. They also said that where the code is silent, common law governs. The Supreme Court of Florida said under the basic rules of statutory construction that statutory laws cannot impair rights given under the Constitution, under a Constitution. The United States Supreme Court said in 2004 that the framers of the Constitution would not have thought it too much to demand that before depriving a man of his liberty, the state government should suffer the modest inconvenience of submitting its accusation to the unanimous suffrage of 12 of its equals rather than a lone employee of the state. They said the jury are the lawful judges. The guy in a black robe is not the lawful judge in a state. The Supreme Court of Florida said that every system of law is generated from systems of, they said the common law of England comes from the they say its substance goes deep into that system. The Christian concept of right and wrong or right and justice. They said the common law comes from Christianity. The Supreme Court of New York said that Christianity is a part of the common law. They said that there has never been a period in which the common law did not recognize Christianity as lying at its foundations. They cite an English court case that says common law is founded on Christianity, and no law can be good which is not founded on Christianity. That's the Supreme Court of New York, y'all. They said Christianity, as taught in the Bible, is not unknown to New York law. What's New York law? The common law of England. Oh, there's nothing in there. How important is the common law? The Supreme Court of Maine said that tax lien is statutory. They said at common law there was no such thing as a tax. The United States Supreme Court said the more modern authorities the government cites also do not support its concept of the criminal jury, although each contains language discussing the jury's role as fact finder. Each also confirmed that the jury's constitutional responsibility is not merely to determine the facts, but to apply the law to those facts and draw the ultimate conclusion of guilt or innocence. Who are the judges of the states? The people. Who are the lawful judges of the states? They said the jury is supposed to be giving the ultimate conclusion of guilt or innocence. They said that the right to a trial by jury is the right to have the jury rather than the judge reach the requisite finding of guilty. They say you could spend 4 years in undergrad, 3 years in law school, and still be told no by the jury because they are the judges of the states. The United States Supreme Court said the jury rather than the judge, say it again, this is another, the jury rather than the judge reached the requisite finding of guilty. The United States Supreme Court said that you, people of the states, are the exclusive judges of the case. Go to a law dictionary and go to the word judges. The United States Supreme Court said due process of law the words by law of the land. Magna Edward Cook in his commentaries said that the Constitution, which had been adopted, that's not what it says. Edward Cook was not alive. Edward Cook is saying that the phrase law of the land means due process of law, as in the Magna Carta. They said the constitutions, which have been adopted by the several states before the formation of the federal constitution, have the same language, which says that by the judgment of his peers or by the law of the land. They said when you go to the Northwest Ordinance Territories in the year 1787, they say the phrase in the Northwest Territory Ordinance used the same words that come from the Magna Carta. So whether federal territory or a constitutional state, there's not one time you should be going before one guy in a black robe to determine your life, your liberty, or your property, because that's not what due process means. Due process means the exact same thing it meant in the Magna Carta. Who is this? This is the Supreme Court of Kansas. No, that's not important. I'm not reading that. All right, let's see. The Supreme Court of the United States said that the guys in black robes were wrong in instructing the jury that they were bound to accept the law as stated in his instructions. They said the people themselves have it in their power to effectually resist the usurpation of the guy in the black robe. You have the power to disregard anything that dude that comes out of his mouth. They say an act of usurpation by the judge is not the law, and any man may be justified in his resistance. They said when it comes down to the judge versus the jury, only the jury can convict him. They are his jury. And if they pronounce him innocent, then not all the powers in Congress can hurt him. And innocent, they certainly will pronounce him if that's what they choose to do. The United States Supreme Court says that the judge cannot direct a verdict. He says he doesn't have the power to say guilty or not guilty. That's not his job. He said they said the jury has the power to bring in the verdict in the teeth of both the law and the facts. Who decides the law? You decide the law. You know how crazy this sounds? They ain't never said that. They said the jury in criminal cases renders a general verdict on the law. They said you determine the law. They said you're the judge. They said when y'all walk in, everybody should rise. They said the jury in a criminal case renders the general verdict on the law and the facts, and the judge is without power. You know how nasty this is? The judge is without power to give a verdict. He don't have the power. It's not been written in the Constitution that he has the power to declare someone guilty. Why? Because the due process of law requires that in order for life, liberty, or property to be taken away from you, it has to be done by the lawful judgment of the peers, the jury. That's why they don't show my live to nobody because they're afraid that if 5 of y'all get this, it's in trouble, bro. They said the jury in a criminal case determines the verdict on the law. Who determines the law, y'all? You do. Say the jury determines the law. They said the judge doesn't have power to give a verdict of guilty. They say it's not possible. Well, that would mean that every judge is giving out verdicts illegally. Yes, that's exactly what it means. Now, look, I'm not making this stuff up. They said the jury in criminal cases renders the verdict on the law and the facts, and the judge is without power to direct a verdict of guilty. They said what the judge is forbidden to do, he may not do, which is try to substitute the will of the magistrate for the conviction of the jury. They say he's never been given the power to call somebody guilty of a crime. That's not his job. They say he is forbidden to do it. They said only the jury can do this. That means every court case that's gonna happen tomorrow, where you go before a black robed guy and he says guilty or not guilty or prescribes punishment without you going before the jury is illegal, is unlawful, is unconstitutional. The United States Supreme Court said the question of fact is in the province of the jury. It must be observed by the same law that you also have the right to take upon yourselves to judge both, to determine the law as well as the facts and controversy. They said both objects are lawfully within your decision of power or power of decision. Oh, here we no, I can't read this one. There's some stuff I cannot read. Here we go. The United States Supreme Court said that the context of the Constitution shows the word offenses only to include crimes and misdemeanors that are triable by jury. They said they never had permission to call something a crime or a misdemeanor where it goes before a guy in a black robe. They said it's never been possible. They do it every day. They said to construe the pardon clause to include support to violate the fundamental principle of the Constitution. They said the language of the Constitution cannot be interpreted safely except by reference to the common law. How do you know the Constitution is being interpreted safely? It's because they define those things according to the common law. They said the statesmen and lawyers of the convention who submitted to the ratification of the conventions of the 13 states were both born and brought up in the atmosphere of the common law. They were familiar with other forms of government, recent and ancient. But when it came down to put their conclusions into a form of fundamental law, they expressed them in the terms of the common law, confident that they could be shortly and easily understood. The Supreme Court of Vermont said that there is that the jury are the judge of law. Who are the judges of the law? Can y'all hear me good? The Supreme Court of Vermont said that the jury are the judge of the law. This is the true principle of the common law. They say whatever you think is the common law, it comes down to this. The jury are the judges.